Siyabingelela. Right. This is my stream.
This is your brain when you're struggling with focus. And this is your brain when you're in the zone. But getting in the zone and staying there, that feels more like luck than something you can control. So that's why we made Brain.FM. It's like a do not disturb setting for your mind. It gets you focused in just 5 minutes. Using science and sound. Brain.FM guides your brain waves to an optimal state for productivity. A whole neural phase login. It lets the parts of your brain work together once it's compared to average music. Brain.FM actually increases and sustains your focus over time, letting you stay in the zone.
Earphones are gone.
You can also use Brain.FM for relaxation, meditation.
These are the people who have spoken. Medidiza. Yes, medidiza. 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 Am I winning?
Class, do you also want to review your withdrawal?
Honorable Speaker, just confirm again the numbers so that we can just see what exactly it is that we are voting on.
Okay.
Because
Remember,
strongly align with the provisions of our Constitution. In its 2017 judgment, the court declared sections 34(1)(b) and 34(1)(d) of the Immigration Act unconstitutional and invalid due to their inconsistency with sections 12(1) and 35(2)(d) of the Constitution. The court found that these provisions failed to ensure that detainees are informed of their constitutional rights, including the right to legal representation. Moreover, section 34(1)(b) did not provide for automatic judicial review of detentions within 30 calendar days, nor did it allow detainees to make representations or appear in person before a court. It also denied detainees the opportunity to challenge the lawfulness of their detention by appearing in court or making representations on the grounds for their detention. The court further noted that section 34(1) of the Act lacked objectively determinable conditions or guidance for the exercise of detention powers, rendering it unconstitutional. To afford Parliament time to address these defects, the court suspended its declaration of invalidity for 24 months until the 28th of June 2019. It further ordered that pending remedial legislation, any suspect detained under section 34(1) must be brought before a court in person within 48 hours of arrest or on the first day thereafter if the 48 hours expire outside ordinary court days. Unfortunately, Honourable Speaker, the necessary amendments were not made before the expiry of the initial 24-month period. However, even after the lapse of this initial 24-month window, Home Affairs continued to uphold the guidelines that were issued by the court, preventing any gap in the law from arising.
In an important demonstration of this administration's commitment to restoring and upholding the rule of law, the amendment tabled before the National Assembly today will finally ensure full implementation of the Constitutional Court's findings. The amendment has also been informed by the subsequent 2023 ruling by the ConCourt, which clarified and supplemented the original 2017 order under Section 1721B of the Constitution, providing amplified, just and equitable relief. Therefore, the Immigration Amendment Bill before this House today addresses the constitutional requirements set out in these two cases by amending Section 34(1) of the Immigration Act. The bill ensures that any illegal foreigner detained under this section is brought before a court in person within 48 hours of arrest, allowing the court to determine whether further detention for deportation is in the interests of justice. It introduces this concept of the interests of justice as an objective criterion to guide both immigration officers and courts, thereby providing the Department of Home Affairs and other role players with a clear standard to meet and introducing greater predictability to the deportation process. Importantly, in addition to upholding the rights of the detained, the introduction of this heightened level of objectivity makes it much harder for any immigration officer to arbitrarily release detainees before they are deported. As Minister, I will use this new law to introduce regulations that strengthen our ability to uphold the rule of law and deport those who are in South Africa illegally. Additionally, upholding these objective standards will ensure that detentions and deportations stand up in court, reducing the litigation costs and delays involved in legal appeals. I wish to extend my appreciation to Deputy Minister Njabula Nzuza, the Portfolio Committee on Home Affairs chaired by the Honourable Moza Chabane, as well as to the Department for their work in ensuring that we finally bring this matter to a close. For the first time, Honourable Members, we will now have a clear set of deportation rules endorsed by the Constitutional Court. In time, this will make for a stronger immigration enforcement system that reduces legal claims against the Department while enhancing our ability to carry out legally compliant deportations more effectively. This amendment is one component of the bigger package of reforms that the Government of National Unity is working on to modernize our immigration system. It will be followed by the publication for public comment of a draft supplementary white paper on citizenship, immigration, and refugee protection, as well as by the imminent introduction of the electronic based on secure biometrics. I also want to use this opportunity to call upon this House to ensure that the Border Management Authority, which has already registered important successes through its embrace of digital transformation, is urgently funded and capacitated so that it can implement its comprehensive modernization plan to build a secure digital border environment. Taken together, Honourable Speaker, these reforms have the power to shape a fundamentally stronger immigration system, anchored in the Constitution and the rule of law, while using digital transformation to enhance law enforcement and secure border management. I want to encourage members of the House to support this bill's passage as a clear signal of our collective determination to modernize and strengthen immigration management, the deportation, as well as the rule of law. I thank you.
Thank you, Minister. Honorable M.S. Chavane, the chairperson.
Thank you, Honorable Speaker, honorable members. The Portfolio Committee on Home Affairs presents this report on the Immigration Amendment Bill, which comes at a time when the country continues to face pressing challenges related to migration. The bill is a technical amendment. It only seeks to comply with the Constitutional Court order, and it does not seek to amend the entire Immigration Act. The House has initiated this legislative intervention to strengthen our immigration protocols with the dual aim of protecting the Republic and promoting inclusive economic growth. This bill builds upon the previous efforts, including the passing of the Border Management Authority Act, as the Minister has highlighted, and currently the committee is processing one-stop border posts as an effort to complement the laws of this country. Pressured by the concerns of South Africans, the Department of Home Affairs, under the ANC leadership, has undertaken in the sixth administration a comprehensive review of White Paper on Citizenship, Immigration and the Protection of Refugee Act, which is delayed, the Minister, for the bill to be tabled limits this House to amend the existing legislation to respond the path this country should take in managing the broader migration landscape. On the 29th June 2017, the Constitutional Court in a matter of law for human rights and the Minister of Home Affairs and others declared Section 34, subsection 1B and D of Immigration Act, as the Minister has highlighted, to be inconsistent with the Section 12, subsection 1 and 35, subsection 2D of the Constitutions. These sections were therefore ruled invalid, and in 2023, a supplementary order was issued by the Constitutional Court. The key aspects was the unconstitutionality of powers of immigration officers to detain individuals based on a declaration of being illegal foreigners without proper administrative procedures. The Immigration Amendment Bill seeks primarily to address these unconstitutional concerns by revising the provision relating to the arrest and detention of illegal foreigners for the purpose of deportation. It aims to align the legislative framework with constitutional rights, particularly those enshrined in the Bills of Rights. As the hallmark of our democratic process, the public participation was central to the work of the committee. After being briefed by the Department of Home Affairs, we advertised the bill widely, inviting submissions from interested persons, institutions, and stakeholders. The committee received a total of 378 written submissions on technical aspects and further conducted oral submission as mandated by the Constitution, reflecting on the broad range of views. These inputs touch both on the specific content of the bill and the broader immigration policy concerns. The latter was referred to the ongoing white paper review process as they fell outside the scope of the bill. A number of substantive issues were raised during the deliberations, particularly in relation to the interest of justice. There were divergent views regarding where the clause should be codified and whether its broad nature could lead to subjective or inconsistent application. In response, the committee revised the clause to empower the Minister of Home Affairs to issue regulations guiding immigration officers on how to exercise their discretions consistently in determining whether the arrest of illegal nationals and release of detainees is in the interest of justice. And this is to ensure transparency and consistency in the application after the President has signed into law. The committee also considered the submission related to the treatment of foreign children, especially unaccompanied minors. Concerns were raised that the bill will lead to the automatic classification of undocumented foreign children as illegal foreigners, potentially resulting in detention in adult facilities in violation of both the Constitution and international obligations. The committee emphasized that children should never be treated as criminals for immigration violations. Detention must also be measured of a last resort, and children must be placed in shelters and treated as children in need for care and protection under the Children's Act of 2005. The amendment introduced, amongst other several important changes, to ensure constitutional compliance to the extent that immigration officers must bring and arrested illegal foreigners before the court of law within 48 hours of arrest. In the interest of justice, detainees for 30 days and further detention must be considered for 90 days in the interest of justice, subject to the reasonable conditions, as the minister also has highlighted. The detainees are granted the right to challenge and or demonstrate lawfulness of their arrest and detention before a magistrate. These provisions collectively aim to comply with the Constitutional Court directive and reaffirm South Africa's commitment to human rights and the rule of law. On the other hand, Honorable Speaker, we are mindful of the initiative as raised by Honorable Ramolobeng, the Chair of the Correctional Service, during the budget vote to amend the Correctional Service Act Section 7, which talk to the length and form of the sentence of foreign nationals. The objective, as we understand, is for foreign nationals to serve the sentence in their country of origin, which will lessen the cost implication and overcrowding in our facilities. We, as the Portfolio Committee, will encourage Minister Schreiber to strengthen the engagement with Minister of Correctional Services on this subject matter. House Chairperson, also Speaker, as we highlighted earlier, the committee is resolute in its view that Department of Home Affairs or the Minister and the Deputy Minister must expedite the finalization of the revised white paper on citizen immigration and refugee protection. This is critical to ensure that our immigration system remain legally sound, human rights compliant, aligned with international best practices. Yesterday debate demonstrated and reaffirmed our collective call for the Minister of Home Affairs to speed up the process of the bill to afford Parliament or this House and all South Africans to have a conversation about the subject matter. We tabled this report, which addresses constitutional shortcomings identified by the Constitutional Court to strengthen the integrity of our immigration system and uphold the values enshrined in the Constitution of the Republic for consideration for this House.
Thank you, Honorable Member.
Universal Greeting of Peace. Assalamu alaikum wa rahmatullahi wa barakatuh. Honorable Speaker, the Immigration Amendment Act 2024 is being presented as a victory for justice. But let us not deceive ourselves. This act is not the product of foresight. It is the byproduct of court orders, a bill born in the courtroom, not in the conscience of Parliament. Yes, Section 34 is being amended. It now forces the state to bring a detained foreign national before a court within 48 hours. It limits detention to 30 days unless the judge rules otherwise. It also introduces judicial oversight, where once there was only bureaucratic power. But here is the truth. These reforms were not guided by government's moral compass. They were forced upon it, first by the Constitutional Court in Lawyers for Human Rights versus Minister of Home Affairs in 2017, and again in Ex parte Minister of Home Affairs in 2023. Twice our courts reminded this very government, justice delayed is dignity denied. Without those rulings, Parliament would not be debating this bill here today. Even now, the Department of Litigation, Department of Home Affairs, is collapsing under the weight of its own inefficiency. Minister Leon Schreiber, happy birthday. You preside over a department crippled by backlogs, broken IT systems and queues that stretch for miles. These failures are not minor hiccups. They are systemic. They are the very reason thousands of people become undocumented. People are not illegal because of their own choosing. They are undocumented because Home Affairs manufactures this chaos. Instead of confronting dysfunction, the bill still clings to the dehumanizing language of illegal foreigners. Words matter, Honorable Speaker. This language fuels xenophobia. It strips people of dignity, and it violates the spirit of our Constitution, which promises equality for all who live in South Africa. And what about the most vulnerable, the stateless, those who cannot be deported because no country will claim them? Those left in limbo, unable to access rights, unable to move forward. This bill offers them nothing but an endless cycle of detention and despair. There are people born in South Africa by undocumented foreign nationals who became stateless. This is because we do not have visionary laws that deal with such peculiar cases. Imagine trying to deport a minor who was born in South Africa, never been to another country. The only misfortune is that they have a mother who's Mozambican and a Congolese as a father. They are unable to obtain a birth certificate and ID document. It means they cannot go to university. Their future, because of lack of documentation, is bleak. A prison without walls, a sentence without end. Let us be clear. This amendment is not a bold step forward. It's a reactive half measure, a legislative bandage on a wound that demands surgery. Procrastination dressed up as progress. South Africa deserves an immigration system that is visionary, humane, and sovereign. A system that secures our border, yes, but also secures the dignity of every human being. A system that does not criminalize desperation, but confronts corruption. A system that does not scapegoat migrants for dysfunction, but holds the minister accountable for failure. So the MK party says directly to you, Minister Schreiber, fix your house before you criminalize the homeless. Fix your systems before you stigmatize the stateless. Fix home affairs before you lecture South Africans about immigration. Honorable Speaker, let it be known that the MK party will not sit quietly while South Africans suffer from failures of home affairs. We will not allow backlogs to become the border. We will not allow inefficiency to become the policy. We will fight for laws that are just, humane, and truly sovereign. Because immigration must never be about fear. Immigration must be about fairness. Immigration must never be about exclusion. Immigration must be about justice. Immigration must never be about headlines. Immigration should be about humanity. Until then, MK rejects the pretense of progress, and we demand justice, fairness, forward-thinking, and sovereignty. I thank you.
Thank you, Honourable Member. Honourable Member Rose.
Right. Thank you, Madam Speaker. This immigration amendment bill addresses defects in our immigration law that were declared unconstitutional in the 2017 Human Rights versus Minister of Home Affairs and others case. The bill intends to amend the constitutional defects of Section 31 of the Immigration Act 30 of 2002, which proceeds detention before deportation. The bill aligns the immigration system with the Constitution, while giving the state stronger tools to enforce the law against illegal immigration. One of the most important aspects of this bill is the introduction of a clear interest of justice standard when dealing with the arrest and detention of illegal foreigners. Previously, too much discretion was left in the hands of immigration officers and magistrates. Decisions to detain or release were inconsistent, vulnerable to abuse, and often not subject to adequate oversight. That created two dangers. First, the risk of arbitrary detention, which the courts could not tolerate, and second, the risk of arbitrary release, which undermined the immigration enforcement and public confidence. This bill corrects that by requiring that the Minister of Home Affairs to set out regulations prescribing the factors that must be considered. Immigration officers and magistrates will no longer be guided by standard operating procedures that were not visible to magistrates nor detainees. They must apply the law against a set of clear and publicly available standards. Importantly, these interest of justice criteria do not weaken our hand against illegal immigration. In fact, the opposite, they strengthen it, because they ensure that every detention and every deportation stands up in court. It is costing South Africa 427 Rand per day to detain an illegal foreigner, and so it is important to prevent endless appeals and litigation that only delays deportations. The bill also restores proper judicial oversight. An illegal foreigner arrested for deportation must be informed of their rights in a language they understand where possible, brought before a court within 48 hours, detained only if a magistrate authorizes it, initially for 30 days and subject to further detention only if the court extends it for up to 90 days at a time. At each stage, the illegal foreigner has the right to make oral or written representations. This ensures that courts, not unchecked officials, make the final decision. By embedding these safeguards, we ensure that enforcement cannot be overturned on technicalities. We protect the integrity of the deportation process, making sure it is quick, lawful, and sustainable. Madam Speaker, let me turn to a group that deserves special mention, and that is children. Migration often hides a child's face. Children may arrive with families, or they may arrive alone. They may be victims of trafficking, or simply caught up in adult circumstances beyond their control. Our Constitution is unequivocal. In every matter concerning a child, the child's best interests are of paramount importance. The bill affirms that principle. It ensures that children are not simply processed as illegal foreigners, but dealt with under our child protection frameworks, particularly the Children's Act. What does this mean in practice? It means a child cannot be detained for immigration purposes except as a last resort, and only under judicial supervision. It means children must be referred to the appropriate child protection authorities, facilities designed for adults. It means the Department of Home Affairs must cooperate with social services, the police, and the courts to ensure that children's safety and welfare comes first. We welcome the assurance from the State Law Advisor and the Department that these protections are already being embedded in law and in practice. But vigilance is key. We cannot allow the rights of children to be lost in the shadows of immigration enforcement. And we also reiterate our call for the Portfolio Committee on Home Affairs to engage with the Department of Social Services on how they process the children of illegal foreigners, but also how they assist South African children in accessing their rightful documentation, so that we defeat statelessness and ensure that each and every South African child enjoys the dignity of an identity and access to opportunity. House Chair, for far too long, undocumented foreigners have been able to enter and exit South Africa at will. And this bill is another step towards stronger implementation of the rule of law. This means being firm in enforcing the law unapologetically and firm in upholding the Constitution. Illegal immigration is not a minor inconvenience. It threatens our sovereignty, places heavy pressure on public services, undercuts employment for South Africans, and creates fertile ground for criminal syndicates. This is why the Department of Home Affairs, together with the Border Management Authority, has intensified enforcement efforts under the leadership of Minister Leon Schreiber. The progress in just over a year has been remarkable. In 24-25, 51,000 illegal immigrants were deported. That is an 18% increase on the previous year, the highest figure in at least 5 years, and that number is greater than the combined deportations of France and Germany in the same period. Immigration enforcement operations have surged from 383 to 1,415 in Q4 of 24-25. This nearly four-fold increase included extensive interventions to uphold the rule of law, dealing with zamazamas and foodborne diseases in spaza shops. This increase in internal enforcement follows a 215% increase in the successful prevention of illegal border crossings in the 24-25 festive season, and a 63% increase in the successful prevention of illegal border crossings over the Easter period. The Border Management Authority continues to punch above its weight, thanks to the introduction of drones, artificial intelligence, and smart surveillance as part of Minister Schreiber's system modernization program. Operation New Broom, launched earlier this year, uses biometric technology to identify and prosecute illegal foreigners. Already in Pretoria's Plastic View settlement, 95 illegal immigrants were arrested. Similar operations are expanding. Now, these results show that enforcement is working, but without the constitutional fixes in this bill, many of these deportations could be challenged in court and overturned. And so by passing this bill, we are locking in those successes on a foundation of legality. Madam Speaker, the people of South Africa are rightly demanding action. They want to see their government take control of immigration, protect our borders, and uphold the law. This bill does exactly that. It ensures that immigration enforcement is constitutional, it protects the rights of children, it equips our officers and courts with the tools they need to deport illegal foreigners swiftly and lawfully. The Democratic Alliance supports this bill because in South Africa we believe that the rule of law is non-negotiable, that children must be protected, and that illegal immigration must be confronted head-on, so that we are not denied the benefits of lawful tourism into South Africa that will help grow the economy and create jobs. Thank you, Madam Speaker.
Thank you very much. Honorable Tembekwayo.
Honorable Speaker, the Economic Freedom Fighters supports the Immigration Amendment Bill. On the 29th of June 2017, the Constitutional Court in Lawyers for Human Rights versus Minister of Home Affairs and others declared sections 34(1)(b) and D of the Principal Act inconsistent with sections 12(1) and 35(2)(d) of the Constitution of the Republic of South Africa. The Constitutional Court found these sections unconstitutional because they denied the detainee the right to representation, and a detainee could be detained for much longer than 48 hours. Our actions
Mace to leave before you leave. This House is adjourned.
What the hell is going on here? Oh my day. Oh Lord. Guys, what is going on here? No, I'm not clicking you, bro. What is wrong with you?
How long?
Oh Lord. I don't know what's going on, guys.
Borders and unchecked migration. Our communities, especially in townships,
Illegal foreigners before the
Born in the courtroom, nothing but an endless cycle. The board.
Detention, fertile ground for criminal syndicates.
On the 29th of June 2017, the Constitutional Court in Lawyers for Human Rights versus Minister of Home Affairs and others declared sections 34(1)(b) and D of the Principal Act inconsistent with sections 12(1) and 35(2)(d) of the Constitution of the Republic of South Africa. The Constitutional Court found these sections unconstitutional because they denied the detainee the right to representation, and a detainee could be detained for much longer than 48 hours. Our actions must at all times be guided by the Constitution of the Republic and not by the xenophobic chants of fringe groups such as Dudula. Immigrants, whether legal or illegal, have a right to appear before a court of law and a right to be represented by a lawyer before the courts. These are rights that were denied to many Black people in South Africa under apartheid, and we dare not deny them to any human being, regardless of their status in the country. The challenges of illegal immigration into South Africa have been in the making for 20 years because of the failure of successive ANC governments to secure the borders of South Africa. The Border Management Agency, which was created recently, is underfunded and does not have adequate resources to discharge their task. Large sections of our borders are not patrolled or monitored, and this has led to an influx of undocumented people coming into the country undetected. To successfully address the issue of illegal immigration, we need to capacitate the BMA, address the pull and push factors that contribute towards the inflow of undocumented migrants, such as regional instability, lack of economic growth, and South African employers who hire undocumented immigrants to sidestep labor laws. The high numbers of foreigners flocking into the country does not have to mean that we lower our basic standards of human dignity that must be afforded to all. The bill will ensure that illegal foreigners due for deportation are handled in a just and equitable manner, and that their rights to human dignity must be counterbalanced with the right of the South African state to maintain its territorial integrity. The bill, for instance, provides that an immigration officer may only arrest for deportation of an illegal foreigner after having thoroughly interviewed him or her to establish whether it would be in the interest of justice for that foreigner to be detained and deported. This provides for a law of general application on how to handle immigrants in a humane and legally logical way. We are in support of this bill. Thank you, Speaker.
Thank you, Dr. Tambekwayo. Honorable Fanemeva.
Thank you very much, Honorable Speaker. And let me also join you in wishing the Honorable Minister a happy birthday. Feels geluk met jou verjaarsdag. I know he's a very young minister, so I'm not sure. I think he's turned 21 today. House Chairperson, or Speaker, on 18 September 2019, during a special sitting of this House, the President of the Republic, Mr. Cyril Ramaphosa, addressed us on two national emergencies: gender-based violence and the spiraling immigration crisis. Speaker, allow me therefore just 1 minute to quickly pause and clarify the misinformation that was peddled this week in the House when we as honourable members were unfairly blamed for not setting up the National Council on Gender-Based Violence and Femicide. Firstly, it's important to note that the act setting up the council was only proclaimed and came into effect on the 15th of November 2024, which is less than a year ago. And yes, while the 6 administration's portfolio committee could not finalize the work, so did the previous government do nothing by neglecting to allocate resources and by failing to nominate representatives from various departments to serve on this council. Moreover, we were told repeatedly that there was no budget for this council, no funds to pay civil society, and a plan for a bloated administrative structure. As a portfolio committee, we could simply not accept this, and we were not willing to set this council up for failure. And I thought it was just important to clarify that. But back to the issue at hand, during this special sitting of this House, the President said the following about our immigration crisis, and I quote, "We know that our people are concerned about illegal migration. We understand the concerns of local businesses struggling to compete against counterfeit goods. We share your frustration that some South African employers are employing foreign nationals over locals, turning workers against workers. Police and immigration officials who take bribes in return for making cases go away or for issuing fraudulent documents must be dealt with firmly. South African employers, be they in the trucking industry, hospitality, or agriculture, must obey the law. We should consider, as many other countries have done, the regulation of how foreign nationals can own and participate in certain types of businesses within the small and medium enterprise sector. And we must acknowledge that there are certain parts of the country where specific foreign nationals have been identified as the main dealers and peddlers of drugs. Those were the words of our Honourable President. Fast forward 6 years later, and nothing has changed. Honourable Minister, the crisis runs much deeper than just our non-existent borders. It is intertwined with systematic corruption within Home Affairs. Some migrants arrive at our borders without documentation, while many others carry fake IDs, fake passports, are in possession of fake study permits and other documentation such as asylum seeker documentation. It is really sometimes just a free-for-all. And you only have to have eyes to see the dire consequences on our communities. Industries like e-hailing, beauty, hospitality, delivery services, and our spaza shop industry is now increasingly dominated or run by foreign nationals. And yet when we raise these painful truths, those who have good jobs, those with medical aids, and those whose children are not on waiting lists at public schools, and those who benefit from employing illegal migrants are the first ones to dismiss South Africans' concerns as xenophobic. They have the luxury of ignoring the real harm inflicted on our nation. The Immigration Amendment Bill before us is a necessary correction mandated by the Concord, mandating that detained illegal foreigners be brought before a court within 48 hours, guided by the interests of justice principles. We support, as the IFP, the rule of law, and believe, therefore, that we must fix laws that violate the Constitution. We further welcome the steps that will ensure greater protection of children. But we must also acknowledge that many illegal migrants lack verifiable addresses or means to be traced or returned to court. This too carries a danger. And Minister, I heard you that we will now be able to execute legally compliant deportations, but this should not be needed in the first place. It is time for migrants to enter South Africa with proper documentation, including medical insurance, which is the case in other countries. In closing, the IFP will support this bill, but Honourable Minister, take South Africans' concerns seriously about illegal migration. We need broader reforms that put our citizens first, upholding the rule of law, protecting our safety, and ensuring our resources benefit South Africans. I thank you.
Thank you, Honourable Member Van Merwe. I allowed you to finish your clarification, even though it was not an opportunity to do so in the debate. The Speaker was going to address that matter because it related to the processes of Parliament. I think next time, chairpersons must try and, even if they feel strongly about the issue, not to take an opportunity on other matters of national importance to address those concerns. I'll now ask Honourable Matopa.
Thank you, Honorable Speaker, honorable members. Today, the Patriotic Alliance stands in firm support of the Immigration Amendment Bill, Act B8 of 2024, tabled in response to the Constitutional Court's ruling in Lawyers for Human Rights versus Minister of Home Affairs. This bill is not merely a technical fix, it is a constitutional correction and a reaffirmation of our democratic values. For too long, the detention of undocumented foreign nationals operated in a legal vacuum, undermining both human dignity and the rule of law. This bill introduces critical safeguards, judicial oversight within 24 hours, access to legal representation, and defined limits on detention. These are not optional, they are the bare minimum required by our Constitution. But let us be unequivocal. Constitutional compliance must not come at the expense of our national sovereignty. The Patriotic Alliance has consistently warned against the consequences of porous borders and unchecked migration. Our communities, especially in townships and informal settlements, bear the brunt of overcrowded clinics, overburdened schools, and rising lawlessness. South Africans deserve a government that puts their safety, livelihoods, and dignity first. This bill is a step in the right direction. It restores legal clarity and operational discipline, but it must be followed by decisive action, strengthening border control infrastructure, fast-tracking deportation process for unlawful entrants, rooting out corruption within Home Affairs and law enforcement, establishing a transparent registry of foreign nationals in the informal economy. Within the GNU, we urge our partners to move beyond legal compliance and towards strategic reform. Immigration policy must serve the national interest, not ideological abstraction. We must protect South African families from the erosion of public order and economic opportunity. Speaker, we support this bill because it affirms our constitutional obligations while laying the groundwork for a more secure, sovereign South Africa. We will continue to champion policies that restore dignity to our people, order to our borders, and accountability to our institutions. Let it be known South Africa is a welcoming nation, but not a lawless one. Thank you.
Thank you, Honorable Van Staden.
Government adds more court appearances and procedural layers without building enforcement muscle. Deportations will be slow, our courts will choke, and communities will be left exposed. Action SA will not support paper rights that weaken real security. We are asking that the playbook be rewritten, that the white paper on international migration is nearly a decade old and hopelessly out of step with today's migration procedures and cross-border